Good afternoon, entrepreneurs, creatives. I see you out there, and we're so glad that you have joined us. Alon, my partner, is going to introduce herself, and I'll introduce myself.
Hi, I'm Elon Moore Jones of the Elaine Law Group. I'm partner with Lorraine.
Hi, and I'm Lorraine Beerville, and together, Alon and Lorraine, we are Elaine Law Group. What we do, we serve creatives and entrepreneurs in the intellectual property space, which is primarily copyrights and trademarks, business law, which is primarily formations and contracts, and estate planning, which is primarily wills and trusts. And you can connect with us online at elainelawgroup.com, by email at legal@elainelawgroup.com, by telephone. We'll put all of the information on the chat so that you can see it.
And we're available through our social media, Facebook and Twitter at Elaine Law Group, and Instagram at the Elaine Law Group. You can also register to receive our free checklist. And Lorraine, I think she's putting that in the chat as well. Okay. Or you can book a consultation with us. We use our client scheduler to book our consultations. So as soon as you book, we'll know. And we will get in touch with you as soon as possible.
Okay, so that information is now in the chat. So you should be able to find it. Thank you so much again for everyone for joining us today. And I hope everybody's ready to get started, because we are. So let's go ahead and dive right in. As we go along, feel free to ask your questions or put your comments in the chat, and we will get to those during the Q&A. First of all, let's start with formations. That is an issue that we hear about all the time that people want to know about. And so let's jump right in on that. There are different types of business formations that you can get. The sole proprietorship, which is the one that you typically file down at the county office. People also know it as a DBA, doing business as. Alon, do you want to talk to our audience about why that probably is not the best idea?
Absolutely. So the sole proprietorship is one that we do not recommend, simply because you hold yourself out to be the most liable, and your liability is pretty much unlimited under the sole proprietorship. You can also only have one owner with the sole proprietorship. And it will probably only be recommended if the business doesn't need any further funding, if you don't have any employees, you don't have a large client or customer base, and if you don't actually deal with money. But we know all businesses are in the business to grow, build clientele, build their employee base. And we want to make sure that your growth can keep up with the amount of liability that you might incur. So then we'll move on to what's considered, like the partnership as well. The partnership is similar to a sole proprietorship, but in a partnership, you have to have more than one owner. With the same set of risks that are open to the sole proprietorship. And the partnership would have to be also open to unlimited liability as well, simply because it's you're not forming or protecting yourself from liability by the actual formation process, as recommended by us and by almost any attorney. Partnerships are risky, as well as sole proprietorships are also risky. Basically, you're not making any distinction between yourselves and the actual business entity. Usually you don't have a separate bank account set up because you usually can. You don't have a EIN number. You also are mixing and mingling funds as well. You don't usually have an insurance policy set up in the business name and things of that nature. So you're really limited to what you can do with what most people get in association with a sole proprietorship or a partnership is what's called a DBA. And those things just simply do not insulate you personally from any liability. And most people are not in the business of being in business to get sued. So in order to receive the protections you need, we move on to what we would consider more insulated and protected types of business formations. Any questions yet, Lorraine?
I don't see any in the chat, so we'll go ahead and move forward with for-profit versus nonprofit. So with for-profit corporations, the reason why we designate for-profit and nonprofit is because actually both types of entities are considered corporations. Sometimes people don't realize that. They are, in fact, in a corporation if you have a nonprofit, even though the purpose of it is charitable. We'll get into that a little bit later on. So right now, what we're focusing on is for-profit entities, for-profit corporations. So a lot of times people ask, S Corp, C Corp, which one should I go with? There are some big differences. So let's start off with the C Corp. With the C Corp, well, let me backtrack. All corporations give you a few things. They limit your personal liability, which is a great thing, which is a big difference from what Alon was explaining earlier with the sole proprietors and the typical partnerships. Where there's unlimited personal liability. If you get a corporation, it does limit personal liability, which is a great thing. Also, though, one of the drawbacks with a corporation, it can have complex tax and legal requirements. They do require a formal board of directors, shareholder meetings, minutes, bylaws, and record keeping. Sometimes that's a bit much for people. And so we'll talk about that a little bit later in comparison to LLCs. Corporations are managed by a board of directors. They elect shareholders and directors make decisions. Also, corporations, you do run the risk of having double taxation. If you have a C Corp, for example, you have to file an annual tax return with the IRS. Then you also have to report any earnings that you made from the company. And so that is when you hear people talk about double taxation, that's what they're talking about is with a C Corp. And so we'll talk about the difference with the S Corp here in a second, but who C Corps are recommended for? Let's go through this. Businesses that need maximum tax and ownership flexibility. That is someone who would want to engage with a C Corp. You want the personal liability protection. There's 3 different vehicles that can help you do that. So that's not necessarily the only place you can get that as a C Corp. It's also a great option if you are adhering or don't mind adhering to corporate formalities and record keeping burdens, and if you want the maximum flexibility in selling shares to raise capital. So those are some of the reasons why someone will want a C Corp. Now let's compare that to an S Corp. An S Corp it's kind of like a merge between an LLC and a C Corp. You get to avoid the double taxation. You don't have you have the pass-through taxation status that an LLC does. The income and losses are also passed to the owner. You may or may not want that, depends on your situation, right? Some of the drawbacks of an S Corp. It does make you more susceptible to audits. You can only have up to 100 shareholders. With a C Corp, you can have, an unlimited number essentially. But with an S Corp, you can only have 100 shareholders. Also, stock owners or shareholders in an S Corp can only be individuals, estates, or certain types of trusts. No company may own stock in another company that's an S Corp. Another thing to think about. So who are S Corps recommended for? Eligible LLCs are corporations that want to save on taxes. So you can elect to be treated as an S Corp if you have an LLC. But in general, I would generally say with all of this, consult a tax professional. to find out if your business would likely benefit from C Corp, S Corp treatment or status. However, we find the vast majority of entrepreneurs, the best option for them is an LLC. And we'll go into that in a moment. I want to go back to what we were talking about earlier about profit versus nonprofit. Because if you're listening to this and you say, well, I'm not a business, I don't know that any of this really applies to me. I'm involved with a nonprofit entity because we are engaged in charitable purposes. Well, guess what? That is still a corporation. And so because it is a corporation, you really want to make sure you're following the same formalities that a C Corp would follow, that you have a board of directors, minutes, record keeping, all of those different things. The reason why is because the IRS is giving you a tax exempt status, and contributors who donate to the organization, there's a certain burden that comes with that, and they want to make sure that everything is being used for charitable purposes and that you're following those guidelines in order to get the benefits that do come with the tax exempt status. And so it's a public charity. Alon,
Pretty much transparency. Yeah, transparency is required. So your donors, your board members, everyone needs to be fully aware of the dealings of the nonprofit and make sure that it's upholding its bylaws and its formation and formalities. I'm sorry. So.
Absolutely. And formation for the nonprofit organization is very similar in terms of process to a for-profit corporation, except that you have to file a 1023 with the IRS. So in the instance of an S Corp, a C Corp, any kind of corporation, nonprofit, all of those you would need to file with the Secretary of State. But for a nonprofit corporation, you also would need to file a 1023 with the IRS. And like Alon mentioned, the bylaws are really important and you would want to have those prepared before sending those off. So now let's transition to our last for-profit entity that we're going to discuss, which is the LLC. LLC stands for Limited Liability Company. And Alon, would you like to discuss, what it is and why do people need an LLC?
Yeah, so I like to think of LLC as like the love child, the love language of the business owner. So we love the fact that it provides liability coverage. We love the fact that it provides flexibility. It protects you from personal liability. It provides, personal liability protection. The formal meetings and minutes are not necessarily required for an LLC, although they are helpful, but they're not required as they would be for like the nonprofits business entity. The management of the LLC is flexible, meaning that you can have members or you can have just managers. The operating agreements that are highly recommended for multi-member LLCs would provide the outline of the duties. The duties are agreed upon for each individual, serves in whatever capacity within the LLC. So, for example, you might have a manager, everyone might be a manager, or you have one or two manager members, and those duties can be specifically outlined in the operating agreements. So that people aren't going outside of their duties. And when they do go outside or breach those duties, then you can refer back to your operating agreements to say, these are specifically outlined duties, and this person went beyond those duties. This is in the event that your LLC is ever sued for any reason. So if somebody was, say, only supposed to open up the windows on Monday mornings, but they decided to open up the windows on Saturday and Sunday, and somebody fell out of the window, now you're being sued. But then you can go back to your operating agreement and say, hey, that person's duty was to only open the windows on Monday. The person fell out of the window on Saturday or Sunday. Sorry, that's the best example I can come up with, but hey, I think it kind of made the point. And so with the LLC, there's no double taxation. It's treated as a default pass-through entity. Lorraine touched on double taxation earlier, but we do recommend always consulting with your CPA or licensed tax preparer when it comes down to doing your taxes. But there's no standard is there's no double tax when it's treated as a pass-through entity. You can later make the election to be taxed as a corporation. Some choose to be taxed as an S corp, even though they're an LLC, and you can do that through your tax designation if you so desire. But we recommend this for any business owner who wants to be protected from any liability. Has minimal corporate formalities, anyone who's looking for minimal corporate formalities, and specifically looking for those pass-through taxation options. So I don't see any questions.
Okay. And just piggybacking on what Alon was bringing up about some of the benefits on the LLC, you don't have those, speaking of corporate formalities specifically, you don't have to have those formal meetings with minutes and record, the type of record keeping that would be required with the corporation. And really, ideally, the LLC is best for business owners who still want the personal liability protection that Alon was talking about, minimal corporate formalities, and that simple pass-through taxation. And while we're on the topic of taxes, I think that's a good time to transition to tax compliance. We're not really going to go into the federal part of this. We are not, let me qualify this, we are lawyers, we are not accountants. We are lawyers, attorneys at law, not tax advisors. But what we do know about this is we help people start businesses all the time. And because we do that, we're also aware of some of the compliance requirements that the state has. So for example, you have annual franchise tax that you need to report. Generally speaking, most small businesses will not have to pay your franchise tax. If your revenue is under $1.1 million for the year, you will not owe a franchise tax for the most part. Certainly there are certain industries where there may be some other taxes that you might have to be aware of. But in terms of franchise tax, the threshold is $1.1 million. However, even though you may be under the threshold and not owe any franchise tax, the state does still require that you report annually because they want to know to track business revenue for the state, to be able to signal to bonds, for example, to make sure that our bond rating is strong, things of that nature. So the comptroller's office definitely wants to still collect your revenue information, but if you're under 1.1 million, you will not owe franchise tax. Also,
we're speaking of the state of Texas. So
yes,
just
thank you
for all those out in virtual world.
And thank you for that, Alon. We both are barred in the state of Texas. We are Texas attorneys. We also delve into some federal practice areas around in the IP space, copyrights, trademarks, and we can definitely connect you with someone who can help you with your patent. So want to put that out there. If you are outside of Texas, come to us for all your IP needs. That is our specialty. But in any case, here in Texas, we also do business law and estate planning. But yes, the tax information we're providing you is state specific to Texas. You would still need to file your federal returns, of course. And one thing I want to mention about franchise tax in the state of Texas, Texas has a really great program for veterans. In the last legislature, there was some legislation passed, and then also in some prior sessions as well that dealt with this. But basically, if you start your business now, you can qualify for exemption from franchise tax for the first 5 years of your business. And so if you are a veteran out there, if you're watching this and you're interested in starting your business, feel free to reach out to us here at Elaine Law Group. The state will also waive your filing fee. So the initial filing fee that the state normally charges, $308.10. you would not be required to pay that Secretary of State filing fee, and you also would be exempted from franchise tax for the first 5 years. So that is a great opportunity. If you're a veteran, you've earned the benefit, might as well take advantage of it, right? And then I want to transition to sales tax. So I know we were talking about franchise tax in the state of Texas earlier. Franchise tax is, what we were talking about. Now we're transitioning to sales tax. Sales tax basically means that you as a business owner are open to the public, selling a product to the public, and by virtue of selling that product to the public, there are certain items that the state of Texas considers eligible for sales tax, and that the business holds those funds in basically trust for the state of Texas for you to return to the state of Texas from collecting it from the taxpayer, in that instance, the person in the general public who's buying the product. You then, as a business taxpayer, forward that funds to the state comptroller's office. So that is an obligation that you have if you are selling to the public certain types of items, such as goods, grocery items. For example, grocery food is not sales tax eligible, but for example, if you were to go buy a burger at a restaurant, that would be subject to sales tax. Tangible products that are not considered certain necessities, you have to pay tax on. So for example, in the state of Texas, you generally pay sales tax on clothes. However, during back to school weekend, sometimes the state comptroller will waive that sales tax. You don't have to pay it on clothes during that time frame. But generally speaking, there are lots of products in the state of Texas that if you're purchasing them at the location or even online, sometimes depending on the relationship of the company to the state, you would pay a sales tax. And so as a business owner, you have a responsibility to forward those funds to the state. That could be annual, that could be quarterly, that could be monthly, depending on your situation. So make sure you reach out to the comptroller's office to find out what your obligations are. But we want to make sure you knew about that. And so generally speaking, if you're starting a business or you're currently running a business in the state of Texas, whether it is your primary hustle, your all the time 24/7 business that you're running, or even if it's a side hustle, make sure that you have researched your industry and that you maintain compliance, that you've procured the appropriate licenses that are required and permits. If for some reason you're not compliant, so let's say, for example, you don't file your annual franchise tax, even though you may not owe any franchise tax, after a certain amount of time, the state can revoke your right to do business in the state. You don't want that. To the point that Alon brought up earlier, businesses that are for profit are in the business of making money and making a profit. And you can't do that if your business status has been revoked. And so it's really important to file your reports on time. Even if you are late, you can still file them late and get reinstated if for some reason you miss your reporting period. And the other issue with, not maintaining a good status for your business, beyond your right to not be able to do business, is any contracts you sign could potentially be invalid. And so with that, I want to go ahead and transition to my partner, because we have some important information to share with you regarding contracts and starting and running your business. And keep in mind, if you have questions, comments, put them in the chat. We're going to answer questions at the end of this conversation.
Yeah, so the basic idea behind contracts is basically to put everybody on notice of what's expected, right? So it essentially helps to set the expectations between both parties. It helps to eliminate any misunderstandings, reduce any risk. It outlines what the parties have clearly agreed to, what consideration was offered in order for the contract to actually be executed. Then it also establishes how disputes might be handled. Disputes may be handled through arbitration. Most contracts these days have arbitration clauses. The other incentive to actually using contracts and executing contracts is that it helps to protect the actual investment that you're putting into the business. It also helps to clarify the liability is that of the business and not one of you personally as the owner. So what we find is to engage in gentleman contracts, the handshake agreements. And although these are, time, you know, time respected agreements that probably your grandparents have always used, or they've always just felt like, I don't want to offend someone by presenting them with a contract, or, people get shy away from all formalities, but in actuality, contracts protect you most as the individual engaging in the contract. Actually protects both parties. It's very clearly stated. There should be no gray area. Both parties should meet with legal counsel to enter into those contracts. It's highly recommended that you have your attorney review contracts and give you any additional language that might be missing, or language that might be a little predatory. Maybe you need a couple of revisions and things of that nature. But contracts shouldn't be seen as the big bad guy, but more so as the thing that brings everyone to the table with some commonality and some clear understanding of what's to take place moving forward. Some of the most commonly needed contracts within a business would be your operating agreement. Again, that's usually when you have a limited liability corporation or any company that has one or more members, not husband and wife, but definitely members that are probably outside of the marital relationship. Husband and wife can also have an operating agreement, but usually when we're talking about multi-member corporations in the state of Texas, at least husband and wife are not necessarily considered multi-member because it's the same household. However, I digress. When you have multi-member corporations, operating agreements are highly recommended, and they must be agreed upon by each party. You might need to have a copyright assignment agreement. We do offer copyright assignment agreements as well to our companies. For the most part, we have logos that are created. A lot of us are not graphic designers ourselves, but we have individuals creating images. You may be creating not only logos, but maybe the graphics for the products that you may be selling. Those agreements help to convey who owns the actual work product in the end. You might have hired that person to do the graphics and the designing of the image, but you need to also solidify that with an assignment agreement. They're now assigning the rights to the finished product over to you. We also provide and recommend non-disclosure agreements or confidentiality agreements. A lot of the things that you're creating as entrepreneurs are also, may potentially be considered like your trade secret. Maybe you have recipes that you don't want shared or taken away from the business once that person leaves or is no longer engaging with your company. You may have a secret method or a way of doing or executing a particular design or pattern or way of completing a particular task, and you want that to remain confidential within your organization. So you'll have individuals sign a non-disclosure or the confidentiality agreement that would come into effect if you needed to, sue them for stealing your idea or taking your process or procedure with them and then applying it to some brand new company that they decided to go and make a spin-off of your original idea and company. So there's non-disclosure agreements, and they can be very handy and much needed in the industry, especially now that everybody wants to get rich quick and go viral and all that good stuff. So you also want to have client service agreements as well as independent contractor agreements. Lorraine, you look like you wanted to say something. Yeah.
Well, I did want to add non-compete. It's just something to think about as well. If Alon reminded me of this when she was explaining about in the non-disclosure situation, you might have someone who you're just sharing proprietary information with in the furtherance of them carrying out projects for you with your business. Well, you might also want something that prevents them from competing with you or taking that proprietary information to a competitor. And so, non-disclosure, of course, you definitely want to do that. And depending on the circumstance, you may also want a non-compete agreement as well. We want to talk a little bit more detail about some of what these agreements do, and then open it up to questions. So the operating agreement, Alon did a great job earlier of explaining, who typically will want one, especially if it's more than one person with who's operating the LLC. It shows, it's basically will guide your business and how you make business decisions. If you don't get one done, many times the state default law will apply. And so the question is, do you want the state determining how you're going to run your business, or do you want to have internal controls through the operating agreement? So sometimes people don't think about it that way. It also can be a tool for business continuity planning. Perhaps you have a certain person in mind that you want to manage your business in the event that you pass. We often say in estate planning, it's not a question of if, it's a question of when. And so you want to have a plan in place so that your business can survive you if you want it to, or a plan to sell your business. And so that is all things that you could actually put into your operating agreement as part of your business continuity plan. Also, sometimes even if you have a single member LLC, sometimes lenders or investors, they won't invest in what your project is or your business unless you have an operating agreement, even if it's just you that owns the LLC. And so that's definitely something to keep in mind and why you might need an operating agreement. Copyright agreements, Alon, really hit it out the park here. So I'm not going to belabor the point, but you might have a logo or photos or video that you're using for social media or your website. If you didn't do it yourself, then you don't own it. And so you don't want to be in a situation whereby you're later down the line trying to secure a copyright or a trademark, and the information you need to do that is created by someone else and you don't own the rights to it. So definitely want to make sure that you get a copyright assignment agreement to protect yourself. Not only that, it's a protection mechanism. Technically, the person who created it has only granted you a non-exclusive license, which means that they could license it to someone else. And so these are all reasons that you'll definitely want to protect yourself and your brand. Non-disclosure agreements. We talked about that earlier, so definitely will not continue on with that. Just want to remind people of a couple other examples: price lists, supplier lists, client lists. These are all, you might not think they're proprietary, but they truly are. They're the bread and butter of your business, and you want to make sure that that's protected, just like you protect your recipes and formulas and processes that Alon brought up earlier.
I do want to expand on that client list. So client lists are very tricky because individuals that may work for your company may feel like they tap into maybe their own personal resources, their own personal networks to create the client list and to build out your company or assist your company in building and growing. But that's also why your employee contracts need to be, Trump tight. To kind of cover that explanation of, hey, as long as you are a part or employee of this company, your client list is now, if you want it to be, your client list is now the property of our business, for the foreseeable future. You want to stay within the industry practices of whatever your particular industry is, so that you don't limit that person's ability to make a living. However, you don't also want them to be able to just build business based off of your blood, sweat, and tears, and then just uproot everything and then leave you kind of high and dry. So that's the purpose of kind of including some of those proprietary items as well, such as a client list. So.
And just so y'all know, we want you to be tighter than Trump because sometimes he's a little loose. But definitely, want to make sure you're on your best footing and prepared to succeed with your business. And then NDAs, we talked about that a little bit earlier. But just want to highlight some things that people might not be thinking about in terms of confidentiality, financial statements, projections, employee training materials, and training techniques. Again, you might not think that that's a big deal, but it actually can be. Moving on to independent contractor agreements. Sometimes people ask us, who is a contractor? A contractor is someone who's engaged in independent trade, business, or profession, and they offer their services to the general public. Just like Alon brought up earlier, gentleman, gentlewoman handshake agreements. I mean, technically by state law, they're agreements, but because it's not on paper, there's a lot that could be open to interpretation, and that devoids the point of a contract. The point of a contract is to know what your rights and responsibilities are, what your obligations are, how are you going to handle disputes. If you're doing a handshake agreement, there is no consensus on that until you go to court. And I'm pretty sure we're trying to help you avoid going to court. And so we definitely want to encourage you to get all of those terms and conditions in writing. It definitely does make for smoother business transactions. The other thing also is, you might just want to know, what is it? An independent contractor agreement. It's a contract for services to be provided to an individual or company that will be classified as an independent contractor for tax purposes. Now, we don't have enough time today to go into, what are, who, how, and who is defined as an employee versus independent contractor. But if you have questions about that, feel free to reach out to us. We're happy to give some guidance on that. Just a handful of more agreements that we've highlighted for you. The client services agreement. Sometimes you'll want to establish terms and policies for your clients, not just other businesses that you're doing business with. So, outlining who the parties are, what the terms are, what services you're providing to the client, payment and payment schedule, if there's a payment plan, what the client's responsibilities are, ownership of work product, dispute resolution. Contracts are not just for suppliers that you work with. Depending on what industry you are in, it might also be for your clients or your customers too. Investor agreements, if you want to raise money, you want to have that in writing so that it's clear what the responsibilities are. Same thing with licensing agreements. If you want to make money off your intellectual property, you probably want a contract for that. So you understand what your royalties might be, and how what the revenue stream is going to look like. And as we always say, and Alon, if you'll take it away here, how important contract review is. Sometimes you may not go to an attorney for a specific contract, but you may want to go to them for an opinion or a second opinion.
Yeah, essentially you want to make sure you're not being taken advantage of. Is this the industry standard? Am I expecting probably more out of this contract than the contract actually entails? So that's the purpose of having an attorney to review your contract for you. Sometimes the language is a little bit more difficult than you might be used to in your day-to-day interactions. We can help, demystify that process for you. Also assist you in negotiating the terms of the contract. If it's beyond what the industry standard may be, maybe the industry usually only has maybe a 30-day clause for guarantees, right? But that particular contract has or requires a 90-day clause, and it's like, no, the standard is 30 days. So we'll counter that particular contract and say, well, we want to take out this portion of the clause and make it 30 days versus the 90 days that are stated here, things of that nature. So you may not have the time to review the length or the depth of some of these contracts that you may encounter. And you also just may need that second pair of eyes to review it on your behalf, have the legal understanding of the ramifications of entering into certain types of contracts. Some contracts are predatory, and some are just not all inclusive. You may need to include a few more details in particular contracts. So we do have a question, Lorraine, in the chat. We're transitioning Q&A now. Yeah.
We
Okay.
are, yes.
I see a question from Stella. It says, my LLC is registered in Florida, but I recently moved to Texas. I plan to conduct business in both states. What are some things I need to do or be aware of?
Awesome. That is a great question, Stella, and a question that we actually get from time to time. So thank you for that. And I'm sure there's other people who are watching or listening who will benefit from it. So yes, if you're conducting business in both states, Texas law, there's something that they look at called nexus. Do you have nexus with the state? Meaning that do you have sufficient contacts to demonstrate that you are making yourself available and are using the resources benefiting from the state. So if you're conducting business, even though you're registered in Florida, you reside in Texas, residing in Texas alone is not sufficient to develop a nexus for business purposes to have to register with the state. However, if you do, you say, I plan to, I'm glad you said plan. That means that you're thinking about your next move and planning how to do that in the best way that's also lawfully compliant. So that is awesome, Stella. So my answer is changing a little bit because you said plan. If you are currently conducting business in the state of Texas, I would definitely say you need to register ASAP. If you're planning to do business, then you have a little bit more time. You can register it as a foreign LLC because you already have a current registration in the state of Florida. If you at some day would like to transition your business from Florida to Texas, that would be the first step of transitioning the business. And then after you transition the business, then you can convert your foreign LLC to a domestic LLC. So that I hope that I answered your question, Stella. We're gonna stay on for maybe a minute or two more just to make sure whether or not you have a follow-up question. I also see some comments in here. Thank you so much, Ms. Vera. Very nice to hear that this is informative. We appreciate that. Stella, I see your comment here. Great info. Thank you. We're trying our best to do our part to inform the community. So we appreciate that. Hi, Renee. Good afternoon as well. Good afternoon. Well, if there's anyone else who has questions, please submit them now. If you think of it after our chat today, that's okay. All of our contact information is in the thread. Our website, ElaineLawGroup.com, our email, our telephone number, as well as our social media handles. And we also have the link in the chat. If you forgot to register today to sign up for our email list, if you sign up, you will also get a free legal checklist for you to use in your business. As a business owner, as a creative person, you might really be focused on your craft and running and building what your dream is, your baby. A lot of times people view their work or their business as their baby. And so if that's you, this checklist might help you just make sure you're dotting your I's and crossing your T's. And it is free. All you have to do is sign up to receive our email updates. And then also in the chat is a link to book a consultation. If you didn't think of your question during our chat today, feel free to click the link and schedule a call with us. If you do book a consultation with us and you decide at a later point to hire us for legal services, we will apply that consultation to the total cost. So it's not as though it's a sunk cost and you pay for the consultation and that's it. But the consultation is non-refundable as well because we are providing invaluable information and that does cost time. So I see Renee, she said, great info, thank you. So that's awesome. I really appreciate the feedback, Renee, and everyone. So with that being said, Alon, I think I can speak for both of us when we say thank you so much for everyone who registered and signed up for our updates and joined us.
Yes, thank you to everyone for signing up and for joining us today. Lorraine, do you want to wrap up now? You want to hold on for a few more minutes, see if anyone else has any more questions or?
Yeah, I think maybe just a minute or so left. I know that we've given a lot for everybody to chew on. It's a lot of information. We pretty much packed a whole semester of business associations into an hour. And so I know that that is a lot
Shout
of
out to
information.
Professor Newman, Texas
Yes.
A&M School of Law.
Yes, absolutely. Absolutely. Professor Newman is, amazing. So a great mentor for us, obviously. So we covered a lot of information that we learned from him and from the law school and from the bar exam and everyday practice. So that's a lot there. So if you need help, please feel free to reach out to us. We enjoyed this. We hope you did too. And it's a lot of information. So feel free to reach out if you need us. We're here. Thanks again, everyone. And I hope you have a great afternoon and weekend. Thanks. Bye-bye.
Bye.